Well, ladies and gentlemen, just as before I introduce our three distinguished panelists, my name is Ron Atkey, and I'm an adjunct professor here. I have funny reminiscence of this room and teaching in this room. I think the last time I was here, I was giving a course as an associate professor in constitutional law, and it was the year 1972. For my sins, I was nominated as a long-shot candidate in the riding of St. Paul's, and the election came halfway through the term, and by pure luck, I was elected by 800 votes. And so came to class the next morning with a real constitutional crisis facing the class, because it was a tie vote for members of the House of Commons. It was 104 to 104. And so we had a real live discussion of what I call the real constitutional law as to what rules and conventions apply in extreme circumstances. Coming now to what I do and teach national security law, which of course borders on the area of corruption. It's a new interface, if you will. I have come into meeting again some old friends called accountability, transparency, and proactivity. And I can do this in a corporate context. I spent 30 years of my practice after leaving politics with the firm Osler Fasken, and did deal with some corporate governance issues in that particular context. And indeed, I attended a conference just a year ago in China on the subject of corruption, and that's where our star speaker was Milos Barutciski, who's going to be our speaker today. He's a senior international and investment trade lawyer from the firm Bennett Jones, LLP, and I'm glad to have him here to share his views and to set the table for the statutory regime within Canada and internationally within which we operate, which I think will be useful to us. And then he will be followed by colleague Gus Harten, who's an associate professor at Osgoode Hall full-time, and not running for political office, I understand, but I did run into Gus. We were in different sides of the large commission of inquiry relating to Mayor Arar in Ottawa under Justice Dennis O'Connor. Finally, a colleague who's probably even older than me, called Michael Robinson, who's been around commercial and business law with his law firm, Fasken, Martineau, DuMoulin, and LLP. Michael has become, I don't say he's acknowledged as the corruption expert, but he's one of them who's up there and still practices in the field and has some interesting stories to tell and some interesting concepts as he deals with what's called the demand side of this business. So with that short introduction, and I would invite you to look at the CVs within your materials to get the full background of the speakers coming before you today, I invite Milos to give us his opening remarks.
Well, thank you, Ron, and it's a pleasure to be here. It's particularly a pleasure to be also speaking with Gus and Mike. Gus and I are not often on the same side of issues. Gus's expertise is an investment law scholar, and my training and practice as an investor lawyer often run head-to-head, but I think you're going to find that our views on this aspect probably mesh fairly well. And Mike and I go back many, many years, and we were both directors of Transparency International Canada. Mike, frankly, on this issue goes back further than me, and I don't mean years, I mean Mike in his practice in the PPP work, the development work that he was doing in various parts of the world, ran into the issue many years ago before it became topical and sexy and the subject of international law, which it is today, which I'll be talking about. I only ran into the issue in the mid-90s in one particular transaction before there was a law, and then got involved in the OECD negotiations. So what I'm going to do, as Ron said, is I'm going to give you I'm going to focus on supply side. And by supply side, I mean the payers. Another shorthand that's frequently used is active and passive bribery. So somehow I despise that terminology because it's completely misleading and frankly meshes right into Michael's topic. Active being the payers and passive being the recipients. In 30 years, or almost 30 years of practice doing international law, I have yet to see one instance, at least of clients of mine, where they've been the active ones initiating the process. The activity is on the side of the bribe solicitors, the extortionists, who the business has a perfectly legitimate project in mind, and all of a sudden you reach one of several gateways, and the gatekeeper will not let you through until you've paid your way, until they see Mr. Green. And that, now, that's not to say that there aren't investors and companies who have made this a way of doing business. Unfortunately, over many, many years, the attitude was, well, you know what, certain parts of the world, that's the way it happens. When in Rome, you do as the Romans do, and that's an attitude and a point of view that has prevailed in many, many companies in many, many industrial sectors and around the world. But the reason I still feel very confident, it's not just my own personal experience, which admittedly is a narrow subset, but there's a rationale behind it as well, that companies rarely initiate the process is a simple one. Companies are not in the business of handing out and sharing their hard-earned profits with hangers-on and rapacious public servants, intermediaries, or anyone else. They go that route when there's either a perception or a shakedown, when they run into a gatekeeper who says, you're not going through. And that's why the notion of calling this the payer side active as opposed to passive, and the receiving side passive, is completely misleading. Now, but let's start there. And as I say, I'll focus on the supply side issue. As I said, for many, many years around the world, there were no laws against corruption overseas. There were plenty. There are barely, in fact, I'm hard-pressed to think of a single country anywhere in the world that doesn't have laws against domestic corruption. Now, how they're enforced is a whole separate issue. Sometimes they're enforced selectively, sometimes they're enforced strategically, sometimes they're enforced, as we occasionally hear in a certain large country, politically, with a view to consolidating power and so forth. But that's not the point. The point is every country, and I can't think of a single one that doesn't have laws against domestic corruption. But until 1999, there was only one country in the world that had laws against foreign corruption, and that was the United States under the Foreign Corrupt Practices Act, which has its own genesis in the Watergate era and all of that. But it was kind of the theory was, you know what, we got to clamp down on corporate misconduct and official misconduct, and the FCPA in 1977 was a byproduct of that, which criminalized corruption of foreign officials by American companies and U.S. issuers, that is, foreign companies like Canadian companies listed on an American stock exchange. The theory, so that was where and the Americans, until, I mean, people say, well, it only started to prosecute in the 2000s. No, that's not quite accurate. From the beginning, there were always a handful of cases on the U.S. Justice Department and SEC dockets, and by the mid-90s, there were quite a few cases, including several with fines in the tens. In Lockheed's case, they were recidivists. They got caught a couple of times. I think a $26 million fine in 95, 96, thereabouts. So they weren't insignificant, and by corporate fine and corporate penalty standards of the day, recall 20 years ago now, they were up there. So, but then because of that, you had a shift in the 90s in terms of the policy thinking and the stakeholders' interests pushing for change and reform in this area. And I think it'll surprise you to hear that the push for change internationally actually came, well, from two sources. The first one, won't surprise you too much, came from the NGO and development community, who were fed up with, frustrated by the siphoning of billions of dollars every year in development and aid money ending up in accounts in the Caymans and the BVI and Switzerland and Jersey and Guernsey and all kinds of other cool places with peculiar banking laws, unlike ours. And so that's where some of the push came from. Believe me, it wasn't from the World Bank, it wasn't from the IFIs, it certainly wasn't from the aiding governments, who kind of liked the idea because they could tie their aid. Sure, you, Shah of Iran, will get lots of aid from us, but there's going to be a quid pro quo. You know, and there's a lot of stuff. In other words, strings and stuff were not a bad thing. So there wasn't a lot of push on that side. On the other hand, you know, development people, the people actually delivering the real aid, understandably, they're saying, you know, let's see that money instead of seeing it end up in the Caymans. The other place, which will surprise you, I think, is, and this was the most effective push to leading where we had the OECD convention and some of the other things that followed, was the US business community. For purely self-serving reasons, which is the US Chamber of Commerce and several other entities and a number of companies, including some who had been stung by the FCPA, were fed up with having to compete internationally against, you know, you name it, Japanese, Italians, Germans, Koreans, Brits, hell, even those dastardly Canadians north of the 49th, who were literally stealing business from under their noses. Remember, paying a bribe to a foreign official was a lawful thing to do under Canadian law. Yeah, it was illegal over there, but that was no concern of the Parliament of Canada, the Government of Canada, or the Crown Prosecutors. So, in fact, until 1996, it was tax deductible under the Income Tax Act. In France, it's actually kind of cooler because you could go to the Trésor and get your ticket and the number that you filed with the tax agencies that allowed you to deduct. It was very systematic. The French are very organized, if nothing else. So that was the environment we come from here, and that's the environment that changed. Changed because the US business community, frustrated at this situation, seeing this monkey on its back, said level the playing field. Goes to the State Department, the White House, and the Commerce Department, said level the playing field. And that's where the push of the OECD comes from, to essentially require the capital exporting countries, the 33 at the time, or actually it was probably less than that at the time, in the early 90s, OECD countries, the rich countries, the ones that were sending money overseas, whose investors were going all over the world, say, adopt similar laws, and the theory being that let's squeeze, just shut off the tap, the source of the payments, by increasing the stakes, the penalties for the payers, and eventually it'll dry up. Now, that's interesting when the capital exporting countries are the United States, the UK, France, Canada, Germany, Switzerland, Korea, Japan. That was in 1993. Think today, look around the world, where's the money coming from? You know, since 2007 at least, or 2008, a large, probably the dominant pool of foreign investment has been from, hello? China, the Middle East, sovereign wealth funds in places like Indonesia and Malaysia and so on. So when we talk about leveling the playing field, it's a different world today. Having said that, the push for introducing supply-side laws did gain momentum, thanks to organizations like Transparency International, thanks to the efforts of many in government and in the private sector to push this through. The result was that in 1997, the OECD Convention against the Anti-Bribery Convention, I can't remember exactly what the full name is, but not unimportant, was signed, and through the entry into force formula, which called for a certain number of countries with a certain proportion of global GDP, or GDP among the OECD countries, came into force when Canada passed the Corruption of Foreign Public Officials Act and ratified the treaty on December 10th, I think it was, 1998, and the treaty and the act came into force on Valentine's Day, 1999. Thank you, big kiss. So that's kind of how it happened. And what was fascinating at the time I was not involved with TI. Actually, that's not true. I see Wes Cragg in the background, who was the founding president of TI, and I was actually one of the founding members at an event you held downtown when there was like, I don't know, 50 of us or something like that. The push came from, in part, organizations like TI, but one of the biggest pushes came from the business community. So I was a member of something called the Business Industry Advisory Committee to the OECD, so being involved in the consultations to the negotiation, et cetera, et cetera. I was watching this go through Parliament. In fact, it went up for one of the hearings. This is a bill, think about this for a second. This is a bill, a substantive bill, that was introduced in the Senate by the government on the, I can't remember if it was the 7th or 8th, but anyway, day one. Got 3 readings on day one, passed unanimously through the House, through the Senate on day one, went to the House, the Commons, day 2, we got 3 readings, passed unanimously in day 2, and got royal assent, I think, day 3 or 4. And then it was law, criminal law in Canada a few months later after the entry into force period. Think of a single substantive piece of legislation in your lifetime that's had that kind of history, and I think you'll be hard-pressed to come up with an example. Now, what the law did was very simple. In its original form, it had one operative provision. It prohibited bribery of foreign officials by Canadians or anyone in Canada, provided you met the Canadian jurisdictional test and of real and substantial connection with Canada. There's a lot I can go on about, both in the elements of defense and all that kind of thing. I'm not going to bother with that. To be honest, when I sit there and do compliance work with companies or explain the consequences of their actions if they come to talk to me a little later, I don't spend a huge amount of time on the elements of the offense. Frankly, it's a total waste of time. The offense is fundamentally simple and should be known to any child. And it's this: if you give somebody in a position of authority or duty to someone else, a teacher, a school monitor, a bus driver, if you slip them a backhander or share part of your recess snack with somebody whose duty is not to let you through that gate, in order to convince them or induce them to let you through that gate, there's something wrong with that. You don't need to have a law degree and bar ads and God knows what else to figure that out. Every self-respecting business person should understand that, and they do. And somehow the mindset that when in Rome, do as the Romans do, it's accepted in this part of the world. It's not accepted anywhere in the world. The fact that, and nor is it tolerated. It's put up, tolerated, sorry, that's an ambiguous word. It's tolerated in the sense that the powerless tolerate tyranny. You can't do anything about it. But let's just ratchet back to 2011, think of the Arab Spring and what triggered a lot of that. Think of Ukraine, what triggered a lot of that. Think of a lot of social upheavals we've seen in this century, and corruption plays an important role in that. And that's what we have in this situation. So when a business says, oh, well, that's the way it's done. Yes, that's the way it's done, but it doesn't mean people like it. And one of the biggest downsides, I appreciate I'm getting close to my time here, one of the biggest downsides in behaving that way and following that dictum is that in those parts of the world where it's done, rule of law is not at its highest, at its apex, and those are the parts of the world where, while governments may be stable for a period of time, when they totter rapidly, and they totter and fall down a cliff very steeply and collapse, shatter. So, and in some parts of the world where you have that kind of government, that kind of behavior, governments fall quickly and frequently. So if you're the one who's in the pocket of, or aligned with the old guys, the first things the new guys do, even if they're just as corrupt as the old guys, the first thing they want to do is drive the spike through Dracula's heart. And the way to do it is you open up the bank accounts, you know there's bribes there, so you charge them. And then you lock them up forever. And by the way, if you're collateral damage, that's too bad. My first bribery case in the late 90s was exactly that, though the company was entirely innocent and a victim of a travesty of due process, and that's my story, I'm sticking to it. But it gives you a sense of what I'm talking about. This is not complicated law. The provisions, Section 3 of the Criminal Code, of the CFPOA, is not a complicated provision. So where do we go from there? So what happens is the law is adopted in 1990, comes into force in 1999, and then for the next pretty much 10 years, nothing. And that nothing means the way it was adopted, against some suggestions to the contrary to the government that, guys, you might want to put someone in charge. No. It was adopted as criminal law. No resources were dedicated. And the way the law was drafted, every police officer in the country, from the RCMP commercial crime folks to the Ontario provincial and the provincial police to the traffic peace officer in cottage country, had jurisdiction. If you were a peace officer with the right the power to charge offenses, criminal offenses in Canada, you had the right to do that. And every prosecutor across the country had the right to prosecute those cases. So, with everyone in charge, no one's in charge. So for the next 10 years, nothing. It wasn't until the pressure mounted on Canada internationally through the peer review process of the OECD. John Sanders is going to talk to us about what's happening at the UN in the follow-up convention. The pressure on Canada from organizations like TI and others was mounting, and Canada was looking like one of the worst performers. And the current government, to its credit, in 2007 established a dedicated unit of the RCMP, 14 investigators, an inspector in charge, supervised. Actually, the founder was the guy who shortly afterward became the superintendent in charge of commercial crime nationally and kept a very close eye on it. And sure enough, you task people with a job, you give them the resources and due course in the fullness of time, they will get that job done. And sure enough, while in 2007 they were established, 2010 they laid their first charges in the Carragher case. We'll come back to Mr. Carragher in a moment. 2011, they laid charges and negotiated a guilty plea by a company called Nyko Resources over bribes paid to the Minister of Energy in Bangladesh. That was a $9.5 million fine. 2011, they executed a search warrant at SNC-Lavalin's Oakville offices. And what else happened? There was another search warrant executed at a company called Blackfire Resources in Calgary. SNC-Lavalin was over Bangladesh again, the bridge to nowhere. Well, actually, it wasn't to nowhere; it was to somewhere. It was never finished. And in the Blackfire case, it had to do with bribes paid to an official mayor in Mexico. 2012, sorry, that's right, yeah. 2012, the head office of SNC-Lavalin in Montreal was raided at the request of the Swiss Attorney General, involving a Mr. Ben Aissa, former executive VP of SNC-Lavalin, who's been lingering in a Swiss jail until recently when he was extradited back to Canada to face charges here. Understand that executing a search warrant is not an easy or simple or inexpensive task. So for the RCMP to search the same company twice suggests that the cooperation that was allegedly given the first time may not have been quite according to the book. So you'll hear more about that in due course, I expect. But going back to 2012 didn't finish with the SNC-Lavalin, the second raid. There was at least one other search warrant that is not in the public domain. I know about it simply because I know about it. But the government has been executing search warrant after search warrant. I've had to respond to production orders under the criminal code for evidence to third parties. They have been actively pursuing this investigation to the point that as of today, the government's, for a period of, for 2 or 3 years in the late 2000s, till about last year, I think, they stopped doing it. They would actually started for a short period of time saying how many active investigations they have. Right now, all I can say is it's somewhere around somewhere between 30 and 40. Now, if you think the U.S., which is a very aggressive enforcer, has somewhere around between 200 and 300 at any point in time, active investigations, we're easily on par. And these are not trivial investigations. I'm involved in several of them. I was acting for, well, I won't get into what, but I am and have been involved in several of them. They're horrendously expensive, horrendously, what's the word I'm looking for, distracting to management, and the consequences are even more severe. Not just the penal consequences, the consequences with your bankers. The second you trigger one of these issues, you will almost invariably today trigger your defaults under your banking covenants, and there dries up the money. And that's for public as well as private companies. So there are some real consequences that come to that, and I'll finish with this observation. The genesis of this may have oddly been in part from a development perspective and also from a business community in the US, particularly saying, level the playing field for us. This is one of those situations where careful what you wish for, because they got it. They got it with the OECD conventions and the push in this area internationally. The US government went from active enforcement to hyperactive enforcement, which has its own problems of a somewhat different sort. Now, to conclude, this has all been about supply side, so-called active investment. Michael will talk later about the so-called passive investment. As I said, there is nothing passive about it, and nothing has been done about that anywhere in the world. IFIs, some international organizations have tried. The UN Convention has rules, which we'll hear about in due course, but practically speaking on the ground, there's very little. There's lots of good work, but it's still in its infancy, if I can describe it that. Part of it is for obvious reasons. You're dealing with the acts of the most senior officials of sovereign states. Kind of tough to, because there's a lot of other stuff that interferes. And then secondly, on the passive side, let me touch on one point that Gus will speak to, is for the investor who's been shaken down by one of these issues and seen hundreds of millions or billions of dollars worth of value evaporate because some rapacious, venal official wants their piece of the action, what remedy do they have? And possibly the only remedy you might have is an investor claim if you're fortunate enough to have coverage of a treaty. But even there, you run into all kinds of problems which make it very, very difficult to enforce. Thank you.
Thank you very much, Milos. Gus, we'll hear from you now.
Good afternoon. It's a pleasure to be on the panel with Milos and Michael and Ron, and I should say I have a lot of respect for the work that the panel members have done in combating corruption, especially through Transparency International. I'm not someone who researches corruption, so maybe I should just sit down. No, I research something called investment arbitration, and I wanted to give a little bit of a perspective on how those two worlds meet each other. And so there are some broad questions I'd like you to turn your minds to, if that's okay. How should states respond to the problem of corruption? What about in the context of adjudicative decision-making? How should the adjudicator respond to a situation of potential or demonstrated corruption? What if the adjudicative decision-making system itself has certain weaknesses or flaws? Would that change your answer about how the adjudicator should be responding to a situation of corruption? And of course, what kind of corruption are we talking about? I had in mind for this conference to do a systematic review of all of the cases of investment treaty arbitration, which I'll tell you about a little bit more in a moment, in which corruption issues appeared to have arisen. And I just ran out of time. It wasn't possible to do something systematic because there were too many cases to cover. So in some way, the issue of corruption comes up in this context of adjudicative decision-making quite a lot. And so instead, I just sort of proposed a few scenarios that seem to me to be relevant. And I'd like you to just think about these scenarios and ask yourself, if you don't mind, what is an appropriate response to these situations? Okay, so scenario one, corruption of the state involving a foreign investor. You might imagine the host government for foreign investment has annulled a contract allegedly because the contract was secured through payment of bribes. Usually this is to officials in a previous government. Second scenario, corruption of the state but not the investor. So this is the case of the honorable investor who refuses to pay a solicited bribe and then has a contract canceled or denied to the investor. And a third scenario is maybe something different. What can we imagine situations where an adjudicator might actually be corrupted in some way? Most obviously, maybe there's a proposal from one of the disputing parties to bribe the adjudicator. How could we respond to that prospect taking place? Okay, so a little bit of background on investment treaty arbitration. It's something relatively new. about 15 years ago, litigation under investment treaties started to explode. You see here a year-by-year reflection of the number of cases that have been brought. These are cases brought by foreign investors against countries. Typically, it's a company, it's often a very large company, that's suing a country because of complaints or concerns about how it's been treated in some way. And it's a booming field of international law and adjudication. Okay, so just a couple of slides giving a little bit of a more background on how investment treaty arbitration works. So these are treaties that authorize the companies to sue the countries directly. Okay. What's exceptional about, one of the things that's exceptional about it is in other rare situations where a private actor is able to sue a country, a sovereign in international law, there's a customary rule that local remedies or domestic remedies, where reasonably available, not obviously futile, they must be exhausted before the international lawsuit can be brought. But that rule is removed, or has been interpreted to have been removed by investment treaties such that quite uniquely, this system, there's no requirement to go to the domestic remedies first. And that's part of why there's been, I suggest, an explosion of litigation. The system is, we would say, asymmetrical or one way in that investors can sue states, but states cannot initiate a claim against an investor. Okay? So it's more like a public law regime than a private law regime. There's a little bit more to say about that, but I'll just skip over that. Broadly, what kinds of arguments do investors make and when they bring a lawsuit against a country? The standards of investor protection in the treaties are quite broadly framed. So, for example, they refer to an investor's entitlement to fair and equitable treatment or full protection and security. And what that means is obviously it's a very loose concept and can be given a range of different meanings depending on who's interpreting and applying the treaty. There are protections from discriminatory treatment, de facto or intentional discriminatory treatment. There are protections against expropriation, which may be direct or may be indirect or so-called kind of regulatory expropriation. There are prohibitions on performance requirements on foreign investors. So, for example, a requirement that you produce a certain amount of content locally to create value added in the national economy. Those kinds of things are prohibited by a lot of investment treaties to a certain degree. And last thing I'll highlight is the cases that they're not decided in an international court. I stress that because I've been, like Don Quixote, calling for an international investment court for about 7 years, and we're not too far down that road, in spite of my efforts. Anyway, the cases are decided by arbitrators whose decisions are not themselves closely reviewed in any court. So they're not reviewed in domestic courts, which is probably understandable, but there's also no international judicial review process. So you have this unique mix of international arbitration and what I would characterize as sort of public law disputes. Okay, so now I'd like to take us back to the first two scenarios. So we now inject these issues of alleged or demonstrated corruption into an investment treaty arbitration. So the first scenario was the host government, at some point, its officials engaged in corrupt activities with a foreign investor. And the foreign investor, now we imagine, has brought a claim under an investment treaty against the country. And the host government, partly in defense of the claim, says, well, this is an invalid claim, or the arguments are invalid because there's corruption behind this foreign investment. What should the arbitrators do with that kind of a situation? First of all, you're obviously going to have a lot of evidentiary issues. What is your standard of proof? And at what point may a burden of proof shift when there's an allegation of corruption? And different tribunals will approach this in different ways. Most take a very strict evidentiary approach, and as a result, in most cases, corruption allegations are found not to have been sufficiently proven. But in some cases, tribunals will take a different approach. For example, they'll expect the host government to provide evidence of red flags, of a potentially corrupt situation, and then shift the burden of proof to the investor to provide evidence explaining where certain money originated. And if the investor can't satisfy the tribunal may conclude that the corrupt activity has actually been proven by the host government. And then what should happen? Well, in a few cases, tribunals have imposed, they've sometimes called it clean hands doctrine, and said your access to the arbitration is denied because you don't come with clean hands. You are an investor who is engaged in corrupt activities. That can be a very dramatic outcome for the foreign investor, because the foreign investor may have a much wider complaint about how it and its assets have been treated in a host country, but the investor now has been denied access to the adjudicative process entirely. So we would naturally understand if some foreign investors would think this was overly strong. But of course, on the other side, there's an argument to say, well, if this becomes known that this is the remedy, then maybe it will create some kinds of incentives on foreign investors to change their own behavior. Another option, well, let's say the claim is allowed to proceed and the corruption allegation is either concluded not to have been proven or is somehow considered irrelevant, dealt with in some other way. The claim can proceed. Now the investor whose contract has been breached may have an entitlement to full market compensation for the economic loss caused by the state's actions to terminate the contract or amend the contract in a way the arbitrators have said is unlawful under the treaty. So is that a situation where foreign investors are perhaps being compensated, almost getting a windfall, if they have engaged in questionable activities? The host government tries to do something about it, faces, for example, evidentiary challenges in establishing the past corruption, and walks away having to pay a large sum of money in compensation to a foreign investor. Nevertheless, the primary remedy that tribunals institute in investment treaty arbitration is a full market damages award. There may be cases where arbitrators say they're awarding full market damages when it looks like they're awarding less for one or another reason, but the basic principle is a commercial law principle of full market compensation. Third option, what about non-monetary remedies? Maybe in some situations this would make more sense. It would give more flexibility to a tribunal to tailor the response to a situation. We can imagine a lot of creative ways in which a tribunal might determine a non-monetary response, or a response based on partial compensation plus non-monetary remedies. But that is not a remedy that is available, generally speaking, to investment treaty tribunals. Arbitrators tend to be locked into the option of a commercial market-based award or a refusal of the claim. There are some creative ways arbitrators may use to try to get around that, but in this adjudicative framework, it just so happens it's very limited, especially your clear option for non-monetary remedies that a domestic court would have is not available. Okay, so let's turn to scenario number 2. This is the scenario of the honorable investor. The honorable investor has stood up to an attempt to solicit a bribe, and the host government has now carried out some kind of punitive measure in the investor's eye. For example, the investor doesn't get the contract, loses to a bidder, or maybe the contract is terminated. What are the responses if the arbitrators conclude that there was an inappropriate treatment of the foreign investor at the end of a long arbitration? Well, here one option is to compensate the investor for full market value of the contractual rights that have been lost. Now, full market compensation, that includes compensation for reasonably expected lost profits. So you may have spent, a few $100,000 in bidding for a contract, maybe more, maybe less, but the actual value is exponentially more than that because of the reasonable expectation of earnings that would have come had you won the contract. Is that the appropriate remedy? Would that be creating fiscal liabilities for states that become unmanageable because of the pervasiveness of inappropriate, corrupt activities in a lot of parts of the world? I think that's an issue that arbitrators may sometimes have to struggle with, is whether when you have a sovereign acting unlawfully, are the commercial principles of full market compensation necessarily the appropriate remedy, even though that may be the one tool you really have available. So another option is perhaps partial compensation, perhaps no compensation at all. Obviously, that gives more flexibility to the tribunal, but as I've highlighted, the treaties tend not to allow that flexibility on their terms. And lastly, what about non-monetary orders against a state? In other contexts where you have problems of systematic problems in a state's conduct. So for example, failure to enforce labor rights. There are some adjudicative mechanisms available. They can be quite weak, but they are available to allow claims to be brought against a state that has systematically failed to enforce its labor laws. And the remedies are often non-monetary. They'll require a program to be instituted by the state to, hire or train labor inspectors. Occasionally there'll be monetary remedies, but tend to be capped. Is something like that perhaps a better response coming out of an adjudicative process that has found one serious case of corruption, but maybe wants to deal with a problem that is systematic? Is that an alternative that is attractive? How am I doing for time? Okay. I do want to get briefly to the last scenario. I'll skip through a couple of slides here that lay out the power of arbitrators on the investment treaties. To sum it up, basically I think they're the most powerful adjudicators in the world. They have power to award unlimited amounts of compensation to foreign investors. And the largest award yet has been for $50 billion. Okay? That was just this past summer. That one kind of blew the charts because the previous largest award was for just over $2 billion. For any country, an award of that size is just profound implications. And what's significant about it, I think, is it's a retrospective damages award, which is well suited in commercial law, but in public law, not necessarily, because what arbitrators are doing is saying a state, a country, in passing legislation or in introducing a certain policy measure or denying a permit, it broke the law in the treaty and now has to pay compensation going back to the original decision. In the intervening years, when the state was in a situation of always some degree of uncertainty as to what the rules actually were, it may have racked up potentially catastrophic fiscal liability because it's a retrospective damages award. It's quite different from other kinds of remedies we see in public law and in international law in relation to a state acting in its sovereign or regulatory capacity. Anyway, I think it's a very profound power that's being allocated to arbitrators who do not operate themselves in your classical judicial process. And I stress, uniquely, are not subject to judicial review. So I'll just highlight some of the concerns which I've described, as Kevin put it, academically at the top of the slide in his presentation earlier. These are concerns arising from the unique use of arbitration to decide on a final basis asymmetrical private claims against the state in its sovereign capacity and to reallocate public funds, unlimited amounts of public funds. That's what's unique about investment treaty arbitration, is that's what it does. Okay, and I would put it technically, specifically. Independence and impartiality, because it's not a judicial process, you don't have various conventional safeguards of independence and impartiality, such as security of tenure of the judge, set salary for the judge, objective methods of case assignment, prohibitions on outside counsel work. So we just dwell on that for a moment. Bars on outside counsel work. Why is it that judges are not allowed to work on the side as a lawyer for an unrelated client? Well, it's because of a concern about sometimes called issue conflict. The judge may be perceived to be deciding the law as a judge according to interests of paying clients on the side. Whether or not it happens in fact, we just prohibit it because of the concern about perception. Investment treaty arbitration is quite common for arbitrators who are lawyers to be repeat players. They're being appointed again and again, and they work on the side as counsel. make matters worse, many of these arbitrations, at least some of these arbitrations, we know are not public. And the only, as best I can tell, the only real check against this is self-disclosure or an affected party to the dispute bringing a complaint, which is then referred either to a domestic court or to officials at the World Bank, depending on which rules you're operating under. And that could potentially lead to disqualification of the arbitrator. But when you have confidential arbitrations, how is any disputing party supposed to know of the full spectrum of the arbitrator's outside counsel work? So anyway, that's just one fairly precise point about how quite unregulated, or I'll put it self-regulated arbitration adjudicative process creates issues of independence and partiality and potential taint in the decision-making process that become relevant to our third scenario. And what triggers this scenario for me is I happened to be speaking last year to a journalist who was in Canada, who'd spent 10 or 15 years in China, and he was writing a book about China. It's called China's Silent Army. I'm just reading it now. It's pretty good. Anyway, he was interested in investment treaties, and I was telling him how it works and how the arbitration process works, explaining the basics. The foreign investor appoints an arbitrator, the state appoints an arbitrator, and then they agree on the presiding arbitrator. And if they can't agree, there's a default appointing authority, which may be the World Bank president or someone else. His reaction was very quick. He said, oh, well, what investors from a certain country with which I am familiar would do is they would attempt to bribe the key arbitrator, which is the presiding arbitrator, that third arbitrator. That's what will happen. Would that happen? I have no idea. Would it actually be successful? I think unlikely, but possible, I suppose. And it created this question for me, what are we supposed to do about that? An actual attempt to bribe an arbitrator. Of course, judges can be bribed as well. So, is there some difference between an arbitrator being solicited and a judge being solicited? Should we be more concerned with one than the other? And how can the institutional structure of adjudication respond to that kind of situation? It seems to me to even go beyond the institutional safeguards I just highlighted, which are important and to me essential, security of tenure, set salaries, etc. But in a circumstance of a carefully solicited, carefully offered bribe, what are the possibilities to deal with that kind of situation? Well, I give 3 possible responses. Rely on the arbitrators, their reputation in the marketplace to sort of sort it out. Allow conflict of interest challenges by the disputing parties or perhaps by someone else. Or introduce all the judicial safeguards of independence that we would see normally in a court. Do any of these, I don't know the answer myself, but do any of those things cause reassurance, some greater degree of reassurance in checking the possibility of bribery or other forms of corruption in an adjudicative process itself? I leave you with that question.
Thank you, Gus. Okay, as our cleanup hitter, I'm calling on Michael Robinson. You going to sit there, Michael, or do you want to go?
I'm going to sit down.
Okay.
I'm too old to stand up for my remaining 15 minutes that Gus has left me here. I will have to go quickly to get through my focused,
You've got 20 minutes, Michael.
Focused thing, which is on the demand side, as Ron had said. Let me begin, though, by saying that to preclude maybe some further questions, I am in full agreement with Gus Van Harten, Professor Van Harten, that what we need, and I've been advocating it for more than 7 years, is an independent world court of investors or an independent investment arbitration or judicial solution court. And there are all kinds of weaknesses with the current system based on 3,000 plus bilateral investment treaties. and I think most of the academics here and others realize that before those bilateral investment treaties got signed and before 1966, when the World Bank formed the International Center for the Settlement of Investment Disputes, no private party had any right to sue and get an enforceable judgment against a state. Didn't exist. It was only state to state. So it was a huge change, and all of the kinks in making it work have certainly not been worked out. Does it need reform? Absolutely. Would the World Court for Investors do the job? Wouldn't be easy, but it's the proper solution. Are we going to get it quickly? Probably not. Do we need people like Gus to keep reminding us that it's not a perfect solution? Absolutely. I, of course, tend to act for investors. So all of this is contrary to the interests, in a sense, of my clients, but it's in the spirit of being honest about the problems with this system. Okay, I'm going to have to go through this more quickly, but anticipating that, I have done a little 11-page summary of my pitch, which is on your desk. And if it isn't, there are extra copies here. And I will just whip through the highlights of it. It's something you can take away with you. It's not very long to read. As I've said at the beginning, it's not a thorough review or analysis of the law. It's a policy proposal for how corruption controls can be improved by new initiatives on the demand side. As Milos said, there have been very few of those. I think he started saying nothing, but recently there have been several very important ones by the leaders of the financing of development. The World Bank, now joined by the other four international development banks or multinational development banks, whatever you want to call them, plus the International Monetary Fund. So you've got the big five taps of money that come down to developing and developed, lesser developed countries, plus the IMF, which bails out countries who are in financial crisis, who have started to take action. And I've detailed that action in my little paper. And I will digress a bit just to mention the Padma Bridge one, which is the World Bank's big change in acting on the demand side, which did come up this morning in a question. And I think the representative here from the World Bank's outstanding integrity vice presidency, whose card I'm looking at, Michel Ratpan, did mention the commission that decided that the senior government officials of Bangladesh involved in the big Padma Bridge project were innocent. I think what wasn't mentioned was that was the government's own commission. And the government is the one that told the World Bank to mind its own business when the World Bank said, "Madam," the Prime Minister of Bangladesh is a woman. She was recently re-elected in a landslide. "Madam, you must do something about enforcing anti-corruption laws against your own people." She said, "First, mind your own business." The World Bank said, "We may cancel the very large loan, which is the foundation for this Padma Bridge project." She then said, and there's a clip. Where's our journalist? He's still here. And there's a clip. I watched it on TV. She said, "So let him. I can get the money elsewhere." Has she? We're not quite sure. There are some countries whose names come to mind as possible sources for that money, and we're talking billions here. So that's Padma Bridge, and to the World Bank's credit, they canceled the loan. And that is an example of the kind of thing that I would like to see done more often by such organizations. Why would that be more effective to work on the demand side? that way? Well, let me just explain a bit of how a lot of major international business operates in my experience. I'm very old. I've been doing this for 48 years, international business transactions and law. There is a huge market for infrastructure in developing and developed countries. Padma Bridge is an example. It's going to do wonderful things for Bangladesh. Where does that money come from? In my business experience, there is a pyramid. First, if you want to get one of these projects financed, and they all need financing, you have to have at least one of the major multinational development banks involved. Why? Because they're respectable. They do their homework. They study what's going on with these projects. They won't okay them or get involved in them unless there's real social benefits, there's ecological issues that have been dealt with, et cetera, et cetera. So it's the good housekeeping seal of approval. The next level of money is export credit agencies. Do not forget them. An export credit agency is set up by a country, and there are scores of them, every developed country has them, to encourage exports of goods and services by their citizens. They will lend up to 85% of the value of goods and services that go into one of these projects. Well, the export credit agencies want to see one of the big five MDBs in as well. A cynic might say because they're lazy and they don't want to do their own homework and let the big banks do it. But for whatever reason, it's an unwritten rule that if you go up to Export Development Canada, they'll say, oh, which bank's in? Oh, your project's in Asia? Well, we'd like to see IFC, which is the private sector branch of the World Bank, in, plus the Asia Development Bank. And when you got them all lined up, have them send us a letter and say, yes, we're in, and then we, the export credit agencies, will come in. Mopping up this pyramid are the private finance sources, international banks, merchant banks, and there is quite a major industry now of funds to finance such projects. And this is huge business. Okay. What I'm trying to say is, if we could do on the demand side, through these major institutions, what they've been doing by their debarment regimes on the supply side, excuse me, you've heard about the law so far in this panel, but we haven't put much stress on the debarment side, but it's hugely important. If the World Bank says, as it said to SNC Lavalin, I'm sorry, fellas, for 10 years, because you misbehaved, we will not finance anything that you're involved in. That is a kiss of death for you doing international work. Why? Lawyers and engineers are a commodity. We're a dime a dozen. You can get them anywhere. And if you're putting a consortium together to do a big project, and it always will be a consortium, you can't have one company take on the risk for all of this, except maybe in the bad old days of Siemens, when they would take them all on and pay all the bribes. But they don't do that anymore. So when you're putting your consortium together and you got to pick an engineer or a lawyer, why the heck would you pick a debarred one, a debarred engineer that's just out of the business? We haven't seen that percolate through SNC Lavalin. They have enough domestic business that they're okay. But I would like to see their book of prospective international projects right now. If there are any on that list, I'd be amazed. The reputational damage of being debarred by the World Bank is huge. Okay. All the other four international, multinational, I'm sorry, I use the IDB. You've been told that the MDB is the more popular one, multinational development banks. All the other four since 2010 recognize the sanction and debarment regimes of the others. So that means The 5 key taps where you have to go to get involved in one of these projects can be turned off by debarring you. There's a system, it's been worked out for a considerable period. It's 39 pages. The World Bank sanctions procedures. It has safeguards. Milos wouldn't agree that they're good enough safeguards, but it has safeguards against the World Bank being the accuser, judge, and jury and chucking you out for no good reason. And it's a process that I think should and could be applied on the demand side as well. Okay, how would that work? Well, I went through the little pyramid about how you do one of these projects. First, where you get the money, and if you don't get the money, forget it, you're not doing the project. These multinational development banks could add systems like this which say, country, unless you have, and as Milos said, every civilized country has, laws on your books against corruption, accepting bribes by your own citizens, and you diligently enforce them, don't come to us for money. We won't give it to you. And if we've given it to you, and then you won't follow through, we'll cancel it, like Padma Bridge. I'll give you the other big institution that has big clout, which has also made progress, and that's the International Monetary Fund. And I've mentioned a particular case here in my handout, my takeaway, and that was when a major loan facility was made available by the IMF to the Democratic Republic of Congo. And I think we all know that the Kabila regime is just corrupt to the core there, and it's really quite sad, and especially since it's a wonderful country with magnificent set of resources and could be a leader, but isn't. Anyway, the World Bank looked at a very suspicious circumstance in which licenses for mining to, incidentally, a Canadian company, were canceled and handed out to some rather suspicious characters out of one of the stands, Kurdistan, I think it was, indirectly controlled by a Russian who lived in lived in England, and they were given to him. And they said, we don't like this. You've got to look into this. I think somebody's been paid off to do this. And Kabila refused, and the IMF canceled the loan facility. Just canceled it. Now, they don't have a system like the World Bank does, where you get your legal protections in 37 pages of due process, but they have the power to do it. So I guess I got to be quick here because I must leave time for proper questions. Summarizing, not all the points I wanted to make, but there are more in this little takeaway handout. I think there is a method of adding efficiently and through a small number of actors. We've only got 6, really, that have all the clout and have all the money and control of the money, to move on the demand side as well. And every economist knows, even a dumb lawyer like me who can't balance his bank book, that demand and supply are inexorably linked. We can have all the sanctions and debarments on the supply side that we want. It's not going to do the whole job. And when we can do it so easily, we must let the World Bank, in effect, off the hook. And what is their hook? Their hook is, look, we're a development agency. If it looks like we're being heavy-handed against the developing countries by being tough on them, even racist, that goes contrary to our mandate. Well, my submission is it doesn't. Your mandate includes stopping corruption. And the guy who really made it happen is Jimmy Wolfenson, when he came in and said, this has got to stop. 15% of the money's going off the top, in bribes and it's not getting anywhere, and I'm not going to let this happen anymore. The next step, logically, is let's work on the demand side too. Now, I hope you'll read some of the other stuff in here. I have a couple of case studies, and there is one thing I'm not going to read it out, but I would like to direct you to. Since I'm a practitioner, and I did say in my little outline that I was going to give you some practical advice. On page 10 here, under, ironically, practical advice, I go through a little list of what I tell clients to do. And I'll let you read that on your own, and I'll shut up and let Ron take questions.
Thank you very much, Michael. Okay, we have 8 minutes for questions, and then we're going to have a coffee break and then come back at 3 o'clock sharp.
Hi, it's
Yes,
Kevin Davis. Just wanted to take issue with 2 things that Milos said, actually. First, I'm sure your clients appreciate your zeal in defending them, but the idea that the investors tend not to initiate corruption doesn't strike me as completely plausible. I suspect it's possible in cases where they're seeking services to which they're legally entitled from a government official. Why would you pay for that? So that sounds right to me. But there are instances that have come to light of firms paying significant sums for services to which they're not entitled. And I think the most striking example would be Walmart in Mexico. And if you just look at the work that David Barstow and his colleagues did at the New York Times in uncovering the kinds of payments they were making for privileges in terms of opening stores that they clearly were not entitled to, and they were clearly initiating, and that was the point of a lot of that coverage. So I don't think that it would be difficult to sustain the claim that that never happens. The second point is much more of a quibble, because I think the general thrust of your remarks is right when you say that very little has been done to tackle the demand side. So in the sense that we don't see international actors or the developed countries, let's say, trying to prosecute foreign public officials. But I did want to point out that there have been a few instances in which this has been done. I'm thinking really of the United States, which is the jurisdiction with which I'm most familiar, where they have tried to, or have succeeded in prosecuting foreign public officials for receiving bribes. So one was a case involving a Mr. Antoine, who was a Haitian public official, a telecommunications official, who was prosecuted in the United States for money laundering, basically, laundering the proceeds of the bribes that he received from a U.S. company. So that was one case. And then more recently, an official of the Venezuelan, basically one of their development banks, was prosecuted for receiving bribes as well, using some fairly creative mechanisms. So it does happen, but I don't want to suggest that that's been a very significant phenomenon. Thanks.
Okay, Milos, can you respond briefly?
Very quickly. First, I didn't say companies don't initiate. What I said in my experience, I can't think of a single instance when companies come. Now think about it where I'm coming from. I'm the lawyer, the company's coming to me and saying, this is the situation we're in. Normally, if they cooked this in advance and they planned it, initiated it, it's a very different kind of conversation we're having. And I've never had that kind of conversation. Most companies are simply very reluctant to part with their hard-earned cash. In a certain culture, and I don't know enough about the Walmart fact, there's been a lot reported, and a lot of it is still a little ambiguous. In many instances, what you have is companies entering into a certain part of the world, and they rely on corporate chains. So a company like Walmart, who I know fairly well, who do have a pretty robust compliance code. How well they implement it is a separate issue, and that's going to come out in due course. But what you also have is very complicated chains, very complicated companies with subsidiaries left, right, and center. And along the line, they're relying on local management, they're relying on local counsel, local advisors, and quite often the attitude at the local level is, you know what, we're just going to do this the way it's done here. How much blind eye turning there is further up the corporate chain, separate issue. So that's the sort of where I want to put it. In my experience, the local culture is what usually dictates it. If that's the way it usually happens at the level of a shakedown, especially the big stuff. The big banks, the big investment banks, when they go, they're not looking to get unlawful rights. They are so anal, if I can use that metaphor, about compliance, because the sanctions that they face, forget about the fines, multi-billion, $10 billion fines, irrelevant if you're Goldman Sachs. What's relevant is your banking rights or your rights to carry on business. And so they take compliance extremely seriously. They don't go out initiating this kind of stuff, never. And that's been my experience with large corporations. I'm not saying there aren't exceptions, but by and large, it really does get initiated at the local level. And the citizens resent it as much as the people who get shaken down. On the issue about demand side, yeah, you're right. There have been, I don't know, 2, 3, 4 foreign officials prosecuted in the United States. For every one of those, I'll show you a bunch of cases where the charges were dropped against people who have connections with the US government, whether they were related to the CIA in Kazakhstan or whether they were related to, you know what. So given that there are hundreds of cases where companies have been prosecuted and a couple of people charged, plus several let off the hook, you know what, it sounds to me like pretty slim pickings.
Question, sir.
Hi, I'm Juan Ronderos. I'm the sanctions case officer for the Inter-American Development Bank, so I'm the one imposing the sanctions on the first instance on these companies on the cross-department system. Just a comment to Mr. Robinson. You mentioned SNC-Lavalin and the Bangladesh case as one of the first cases in which the World Bank got into this, but in reality, the World Bank had suspended loans before in relation to investigations in India and in Cambodia. Cambodia was a very interesting case because the Cambodian government had to change some of the things they were doing, and they had to comply with some of the requirements that the World Bank had. The India case was a very interesting case because it had to do with the health sector, and that was after the World Bank conducted a detailed implementation review that showed significant issues in the health sector, and at the time in which the British government wanted to invest a lot of money with the World Bank in a health project. Now, the interesting thing there is that there was a lot of opposition from the board, within the board of the bank, and there was huge discussions within the board. And my point to you is that it is an interesting proposition to get banks being serious and getting tough on the countries they serve. But we should keep in mind that these banks are public institutions, are international institutions that belong to those same countries. And that is an added complication to that argument.
It's up to the citizens of those countries to make their case to the governments. That's one of the points I made in my little handout. I agree with you completely. There got to be more people complaining about to their government, the Canadian government, saying, guys, pressure. We want you to do more on the demand side too. Get the poor banks off the hook.
There's a mobile phone app in India that allows people to pipe in regularly. Right. It's become a huge, taken off massively.
Right.
We have time for just 2 more questions, and they must be short. Thank you, sir.
Right. My name's Kenning Marchant. My question relates to bribery and corruption as an international trade issue. The United States and the EU require that imports of tantalum, tin, tungsten, and gold not be conflict minerals. In the area of human trafficking and forced labor, the U.S. federal government procurement by executive order in California for all companies doing business there by legislation requires similar certifications. What are the prospects for international trade rules requiring that goods moving in international trade or imports be bribery and corruption free?
Slim to nil. When we have the where the dough around is dead, we've got spaghetti bowl of treaties going all over the map. It looks like the Trans-Pacific Partnership is dead. The U.S. agreement isn't going anywhere until you stop, until the U.S. stops bugging Ms. Merkel's phone. I just don't think it's going to happen. It's a great idea. It's a wonderful idea, but I don't think it's going to happen.
Last question, please, Michelle.
Actually, one observation and one question. So, Milos, I liked your presentation. It was very good. I just have to say, from my experience in investigations with the World Bank, there really isn't a distinction between small, medium, or large companies in terms of willingness to pay bribes. And I do think that there should be more of an emphasis, or, I mean, I think a more round way to look at this is to see that those companies are willing to pay bribes in almost any circumstances, even the large American companies. I mean, it's just, it's not necessarily local pressures that are really dictating it. If a company is able to, they just will. I mean, that's just the way it works. I don't know if you want to respond to that, but I just...
Sure. The simple, you just answered your question for me, or to the extent there was a question. If they're able to, they will. In other words, if somebody's asking for it, they will. Not automatically, because that's not the default option.
Right.
But if that's the way, this is the old issue of, it's like my kids. This is a compliance challenge for me in a professional way when I deal with clients, but it's also a compliance challenge at home. You know, I got 3 teenage boys, and they will ask me for things that they know darn well they're not going to get. And sometimes the answer is no, and they walk away. Disappointed, but they walk away. It's the same thing on the compliance side with clients. They don't, quite often clients don't understand that you can say no, and they will often walk away. So that's an issue, but I don't need to say more often than not. I have yet to see an instance, and I've been doing this stuff longer than anybody in this country since the mid-90s. In fact, the first big case that you guys did, the Lesotho Highlands case, I was the lead defendant's lawyer. You want to talk due process? Maybe we'll have another panel about how the World Bank does due process, because I've worked on 3 other World Bank investigations, and while it's 23 pages long, and it was cleaned up on paper several times. You had the former Attorney General in the U.S., then Paul Volcker. There have been several processes. I've done cases under the current regime, and to be honest, the World Bank's a complicated place, and it's highly, you know, INT does a great job. I don't want to get into specific. All I'm saying is that the experience of, how should I say, what you guys see and what comes out is not necessarily reflective of what's on the ground. That's really all I can say.
Okay, I don't want to
debate
I know.
too
much, but I will respond to that quickly.
Sure.
Just to say that, well, in my view, and I'm a Canadian lawyer, I mean, I was educated here, I worked for the Department of Justice. I think the due process procedures that we have within the World Bank and within INT specifically are very robust. In fact, they're more robust than I've seen in the civil litigation context and criminal, often, working with police.
We'll have a conversation later.
Yes. The other thing I just wanted to mention was, and again, for later, just to think about, or maybe for other people to think about, is that one of the hardest investigations or schemes that we have, or we try to find and we are not able to figure out, are bid rotation schemes. And when you talk about companies, it is the companies that are often initiating those schemes to decide, and everybody probably knows what that is, but that's the idea that one company will win one project and another company, and they have it all decided between themselves and with the government.
That's a fascinating, I spoke in Montreal at an engineering conference last week on that issue, and it's not really corruption, it's bid rigging, it's price fixing, it's a competition law offense.
Right.
The two are related, and the overlap between the two in both instances, in corruption on the one hand, and in antitrust, price fixing, bid rigging, they're both rent-seeking exercises. They're exercises that seek to undermine the integrity of a market and the integrity of the efficient results that come out. In the context of corruption, what you're doing is underlying the integrity of the decision makers, those responsible for decision-making on the part of the institution, and it's private or public. If you're paying kickbacks to the purchasing manager of your biggest client, private or doesn't have to be a public entity, it's the same thing. You're undermining their ability to tap into the most efficient source of supply. On the bid rigging side, it's pretty much the same thing. You're extracting a rent that economically you're not entitled to. It's not the same thing as a corruption issue, and that, I do agree with you, that kind of thing is systematic in certain industries, but it's systematic particularly in industries where you kind of treat these things as commodities, where there are large dollars. Construction is the most obvious one, where there are massive dollars involved, where politicians, and this is the demand side of it, where politicians view public procurement and think only of defense because it's usually exempt from all procurement rules, or most procurement rules of bid challenges. They view that as a form of patronage. We hand out the contracts the way, you know, in nice ways. So what you have very complex decision-making systems. You have large piles of money, which, you know, like the things that attract flies, they attract all kinds of people and behavior. And ultimately, you have rules that are easily gamed. And then, of course, you attract a certain kind of business. It's not a corruption issue. It's a systemic and endemic issue that cuts across all sectors, private and public.
Right.
Ladies and gentlemen, on your behalf, let me thank all 3 of our panelists and their questioners for a very interesting discussion.